Welcome to Clarke Willmott's webinar, Practical Guidance on the Coronavirus Job Retention Scheme. This information is accurate as at today, the 4th of May 2020. This information we are about to give is general information, and accordingly, should you require any individual advice, I would urge you to get in touch. My name is Paula Squire and I'm a partner here at Clarke Willmott. And on behalf of the Clarke Willmott National Employment and HR team, I'd like to welcome you to this session and thank you for joining us. As any of you will be aware who have been following the Coronavirus Job Retention Scheme, the guidance has changed on a number of occasions, and accordingly today I'd like to run you through my understanding of the scheme, and then I would like to stop and pick out some questions that we've been asked very frequently by a number of our employer clients in order to guide you through. As we're all aware, the national pandemic of the coronavirus has had a massive and substantial impact upon so many employers. However, in response, the government pledged to offer financial support to businesses in order to try and see them through this crisis. Now, as with any response brought about so quickly, the guidance has changed on a number of occasions. But as the scheme is now in use and people are starting to receive their payments, in which case we hope that this will be the current scheme that you can all rely upon. First of all, let's look at you as employers. And we act here at Clarke Willmott for a number of employers. We have been advising on the scheme all day, every day since the scheme came about. Now, the first change here is to note that you, as employers, must have a PAYE payroll scheme, which has been in place since the 19th of March 2020. And I think the reason for that is when the scheme came out, there was some concern that employers may, for example, the unscrupulous employers may put family members on the scheme at a late date now that it's been announced and try to reclaim sums that aren't rightly owed. So in which case, there are a number of cut-off dates that I will guide you through. But the first cut-off date for employers, of course, is having this PAYE system in place. And essentially, employers will need to furlough their employees and workers. Now, I appreciate the word furlough isn't something that we were all familiar with previously. It's perhaps an American term, and prior to the JRS, it wasn't a category of employee or worker that we had used before. But effectively what that means is that an employee will be asked not to carry out any work, and they will go home or be at home already. And in which case you were then able to put in a claim to the government for 80% of that employee's gross monthly wage, up to a cap of £2,500 a month. But on top of that, you can also claim national insurance contributions and a minimum automatic enrolment pension contributions based upon that 80% salary. But what is very crucial to remember is that the scheme is run by HMRC. It's a scheme run that you can reclaim monies. It doesn't impact and it doesn't change UK employment law. The rights your employees had before are the rights they have now, and accordingly you will need to make sure you go through certain hurdles and do certain things in order to deal with your employees, to ask them to be furloughed and to implement the scheme in order that you don't get yourselves in trouble. You will also have seen that the scheme duration has also changed. So previously the scheme was open until the end of May. However, now the scheme is operational from the 1st of March to the 30th of June. The scheme is open to all UK employers, and that's regardless of size. So it can be from the corner shop all the way through to Marks and Spencer's, who are able to access and be eligible to enter into the scheme and seek the reclaim from HMRC. It also includes charities. It can include academies, provided they're already not receiving funding for those employees. Now, we have been asked a few times by employers whether or not they should use the scheme. And my answer to those employers are, if you're eligible for the scheme and you are able to make that claim, then why wouldn't you? The scheme is only open for a short period of time, and we'll have already seen that the economy has taken a massive hit with the coronavirus. So it's best if you can make use of the scheme, and of course, you have valid reasons for using the scheme, then why wouldn't you? Of course, we have seen in the headlines that a number of very large businesses are using the scheme, and indeed perhaps some of those have come under criticism. But of course, we have seen that criticism has, for example, with Victoria Beckham, seen her turn things around. I thought you might find it interesting to see perhaps how much the scheme has been used since it's been put in place. Obviously, the scheme is now open. You are able to access the government portal in order to seek your potential monies. Even on day one, we saw that 1.3 million employees have been furloughed. And a few days later, we saw that that figure was up to almost 4 million. We've seen that as at the Thursday, the 23rd of April, the cost to the government would have been £4.45 billion. So it is a massive scheme. So we've worked out whether or not you as a business are eligible to look to reclaim, but let's look at your employees and are you able to make a claim for them? So who exactly can you furlough? So first of all, I think the basic premise is that whoever you need to furlough need to be on your PAYE system. So that can be employees, of course, but also potentially your PAYE workers. So that could be things like agency contracts, or for example, flexible or 0 hours contracts as well. The employee can be full-time or part-time. The real key here is that they've been on your payroll and they have been on there since the 19th of March. The scheme is also allowed for, with some slight changes, for employees that are rehired. Now, we have seen perhaps at the start of the problems in the pandemic, employees who were leaving for new positions and new jobs, who are going off to find something new or have new opportunities lined up. Obviously, a lot of those have fallen through. We've advised a lot of employers about withdrawing job offers or delaying job offers until they're able to work through whether they can indeed take those employees on. So the scheme did allow for those employees who perhaps have fallen between the cracks to approach their previous employer. And effectively the dates are these. So if an employee has left you and they were on your payroll as at the 28th of February and they left you by the 19th of March, then in which case they are able to come back to you and ask to be rehired and furloughed. Now, don't forget, of course, a furlough period has to last for 3 weeks, in which case do make sure that you've got the right amount of time left that you can take advantage of that. And I would very much strongly urge you to consider a very carefully worded re-engagement agreement in order that when the pandemic comes to an end, when the furlough period comes to an end, the employee's potential employment also comes to an end, so that you don't have to continue on with that. Just making sure that all expectations are set out in order that that comes to an end without a problem. So we've worked out that you as employers are eligible. We've also worked out what category of worker is able to be eligible under the scheme. We've also worked out the dates of which they're employed or on your books in order that you can make the claim. But moving forward, you may have seen a lot in the press that originally the scheme was put together to avoid redundancies. So there was very much an emphasis upon saving jobs for those who otherwise would have been made redundant in order to access the scheme. However, as the guidance has gone forward through several reiterations, we have seen that they've actually relaxed that view, and that effectively what the government are now looking at is really an assistance program designed for those who are affected by coronavirus, who are impacted in their roles. So what we have seen, for example, are a few additional categories who are eligible under the furlough scheme. Now, the first are fixed-term employees. So if I had an employee whose employment was due to come to an end, say today, then in which case what I could do, instead of allowing that to elapse, because of course potentially they may be finding it very difficult to find a new position right now, what you can do is you can extend that fixed period of employment and you can then furlough them. So I appreciate that normally that fixed term employees job would have come to an end today, but what you can do is you can extend that on based upon furlough. However, what I would say is make sure that your correspondence is very clear in order not to set any expectations in the wrong direction, to make sure that you again show that you're being kind and good to your employee to see them through this difficult period. We've also got sick employees, so let's think again around those employees. Previously, we have seen, I suppose, again, if they're impacted by coronavirus, an employee who's on SSP cannot also get furloughed, so the SSP has to come to an end, but the government then said you are able to put those employees on furlough. Now, it's not supposed to be a scheme to cover short-term absences, someone who phones in sick with a with a poor tummy or a normal cold, but in which case with this scheme you are able to furlough. And don't forget, there obviously is this minimum period of 3 weeks, so again that's likely to move away from those short-term absences. Perhaps one of the biggest categories here is shielding employees. So those employees that you might have who, for example, have received a government letter to say that they shouldn't come into work, or perhaps they are shielding for a family member who happens to live with them who's particularly vulnerable, so that they again don't feel that they can come in and place themselves at risk. Now, in which case the government has said that you are able to furlough those employees. So again, providing you're eligible, provided they're eligible, again, there's no reason why you cannot put them on furlough and look to reclaim those relevant monies. Lastly, of course, are employees with caring responsibilities. We've all been hit by homeschooling and the closure of schools, and in which case for those employees who don't have any childcare, again, because they're impacted by reason of coronavirus, you are able to furlough them. So I hope that clears up a few of the other categories of what you can do about various groups within your staff. So once we've worked out potentially those groups of staff that we may want to furlough, let's also then talk about how we furlough those staff. The real key here in terms of how you put an employee on furlough has to be this first bullet point, which is with agreement. Now, previously at the start of the JRS scheme, there was a lot of discussion around just putting your employees on furlough and looking at whether or not you had certain clauses in your contract, for example, for layoff, to work out if you could simply just ask them or tell them to be furloughed. Now, we've also seen perhaps a number of employers who, and probably rightly so at that time, relying upon the guidance that was open, they may not have asked their employees if they are happy to be put on furlough. What I would say to them is to make sure that you try to correct that issue now, to obviously get their consent signed off so that you can hold that on your file. But the real key here is when you're approaching your employee, is to be open, to be clear about what you're asking them, be really clear about what their pay will be on the period of furlough. Make sure that you get that documented and signed off by the employee to say that they agree to be put on furlough. And what I would say is with a well-worded letter to really explain to the employee that potentially you're trying to save the business money in terms of the impact for the coronavirus and obviously moving forward in order to safeguard jobs. I would say that I've actually not seen very many employees at all, hardly any, looking to refuse to go on furlough. And what is taken is more discussion, more understanding of their concerns and queries in order to move that forward and over the line. But also do remember, and again, consider what it is you're offering. Are you offering the 80% government scheme, which you're absolutely entitled to do, or are you going to top that up? Now, I would note you're under no obligation to top up. But again, the choice is yours as to whether or not you do or don't want to. And I've seen probably with all of the employers I've helped with the furlough scheme, I've probably seen about 80% use the 80% and probably about 20% of those employers who are topping up. So I do think there's perhaps more of a balance and a shift towards that 80%. But again, each business to their own. And if you'd like assistance with any of your letters, then please don't hesitate to let us know. We've written, as you can imagine, a vast amount of requests. And as I say, those are all coming along quite nicely in terms of employees embracing the reasons behind it and agreeing to help their employer out for this limited period of time in order that they can safeguard their jobs moving forward. Now, if you do have staff councils, if you do have trade unions, do make sure that you keep them informed and up to date with what you're doing in order that you can move through your process. Also, you do have to consider whether or not you should be collectively consulting with staff. And I would strongly urge you to seek advice if you are at all concerned. We're also seeing at the moment perhaps a raft of employers who have originally put employees on furlough and are now asking them to extend the period now the government scheme has been extended. And what I would say to you again is it can't hurt, and it would always be my preference to have that agreement signed off in writing in order to make sure that you are going through the right processes. Again, I've seen a number of letters that did include rights to automatically extend, but given the government inference and preference for agreement, I would say that I would like to see that as a request more than an imposition. So I mentioned there briefly about collective consultation. As you may know, if you have more than 20 staff that you are going to make redundant, you would need to go through collective consultation rules. And there are some pretty hefty penalties by way of compensation if you don't do this properly. What I would say is if this furlough scheme you are implementing within your business is very much a stopgap before you then move them through to be made redundant, then my view is that collective consultation would potentially be picked up. However, if instead you are simply looking at furloughing staff, you haven't gotten to any potential redundancies or considerations of that so far, and you are literally looking to utilise the scheme for the time being, then in which case you shouldn't be impacted by the collective consultation rules, but do seek advice. Each business and their own plans obviously are very different to another. So very much the link to collective consultation is very much linked to your considerations of what will happen next and where you will go from here. But like I say, because of the strong financial penalties, up to 90 days pay per employee, in which case for those over 20 employees, then in which case, again, do be very cautious. You wouldn't want to fall foul of that. So let's look at the terms of furlough. So as I said, we have reviewed if you yourselves as employers are eligible. We have considered what employees you are able to furlough. We've considered how you furlough them. Moving forward then, let's consider those potential terms. Now, I've already noted this a few times on the way through, but you are supposed to be furloughing your staff for a minimum period of 3 weeks. We've also seen a number of employers use a rotation scheme, particularly if you are offering only 80% of pay. It may be fairer to all involved if you do indeed rotate it through staff, so not everyone is financially limited in that respect. If, of course, you are able to take employees on and off of furlough, and if you do still have jobs to do back in your businesses, obviously depending on the nature of your industry and the type of business that you run. I've also seen perhaps some disgruntled employees who have perhaps gotten the wrong end of the stick or aren't quite familiar with all the terms as we are. Some of them don't like to be called a furloughed employee. We do, of course, appreciate that this is a government phrase that comes with the scheme. So again, just make sure that you explain what furlough is very well. I've also seen some employees question why they're not being rotated with their co-workers. So again, do consider that. Do also be careful in terms of who it is you select to go on furlough. If everyone in a particular category, for example, everyone on your reception desks are impacted, then of course there's a natural reason why you have picked them for furlough. Just keep that documented. However, if you are considering to take, say, 5 out of a team of 10, then again, do be very careful with your selection of how you do that in order that you don't have criticism from those employees you pick as to the basis of that. And to, again, be very careful that that isn't discriminatory. For example, you aren't picking those employees who, for example, have illnesses or underlying conditions that might give them protection, for example, under discrimination law. To also consider if you are rotating your staff or if you are allowing your furlough to stop and start, to make sure that that is very clear in terms of that consent that you are obtaining, and you will need to keep relevant records for 5 years. Now, we have been asked a lot of times about what an employee can do whilst on furlough. Are they able to be put on furlough and then volunteer their services back to their employer? Can they come in and train staff? Can they do anything for the employer whilst they are on this period of furlough? Now, my advice to them is be very cautious, because anything that you do may impact upon your ability to reclaim your 80% from HMRC. And we have seen a campaign by HMRC to encourage employees to notify them if they have indeed been asked to carry on working and are carrying on working while supposedly on furlough. So the first basis has to be that your employees are supposed to be at home, not working for you, and in which case then you should be fine. But again, just be very cautious. The employees are not supposed to be providing services or generating revenue, and that's the phrase that the HMRC are using and the government guidance. And if that is the case, if holiday can be used, there's been a question of whether or not you need to top up the 20%, or whether or not, because they've agreed with you to accept 80%, is that okay? And my view is that if you are having an employee use their holiday during a furlough period, you should top up, and you are required to top up those 20% for the minimum requirement days. So for those 28 days of the year under UK law, you should be topping up the 20% at the very least. And whether or not an employee will agree to have their holiday, because obviously we have seen a number of employers who would like to encourage and ask their employees to use their holiday allowance. First of all, I would say that you can always encourage and you can always ask employees to do the things that you want them to do, like take holiday, and in which case there is no notice requirements allowed in that. You can discuss that and agree that and have them sign to confirm their agreement. Alternatively, potentially you can look to have them keep the holidays that they've already booked, again, provided it meets within your own contractual provisions around holiday and booking and revoking holiday in that respect. We've also seen that government has confirmed that for the minimum European allowance of 20 days holiday per year, and you are required to allow them to carry that forward. So if they are, by reason of the coronavirus, not able to take it when business resumes, they are able to take it over the next 2 years. So that's another right that kicks in here with regard to furlough. And for any further advice in relation to your own holiday schemes and provisions, don't hesitate to get in touch, and we can talk that through specifically dependent upon your plans. Which brings us to notice periods, and I think again it's the same principle of, for example, if an employee is working out their notice period, are they able to continue that on during furlough? And again, I think everyone's best to guess on this one, subject to any opposing confirmation by the government, is potentially that you can, provided again that again in terms of moving that forward, it's all very well documented and the employee is working through their notice period. The question again arises as to whether or not you need to top up that 20%, and I suppose again the discussion of the fact that they have agreed in writing to accept a reduced amount of pay down to 80%. So some employers have chosen to top that up by 20%, or indeed rely upon the fact that the employee has agreed to accept less pay for that period. And I suppose that we will see then whether or not there is an argument or a surge of employees looking to claim that 20% once the coronavirus scheme obviously has played out, and once they have finished off their employment, to see whether or not again there is any clarity over that 20%. So what can you claim? What can you put into your claim to HMRC? Let's run through some of the advice in this regard. So as we've seen, you can reclaim 80% of your employee's salary before tax up to this maximum threshold of $2,500 per month. You can include certain regular payments, but there are some payments that you're not to include and you're not to put through, for example, gym memberships or benefits such as private medical health, etc. Those are the types of claims that you're not able to put through. And so what you then look to pay on to your employee will very much depend upon what you have agreed with them in your furlough letter, and also whether or not you then top up at certain elements or you keep certain benefits going throughout this period. We've also been asked the question about, well, what about those employees with irregular pay? So those employees that week by week, month by month are not paid necessarily the same amounts. Now, what the government has said is that if they've been employed for the previous 12 months, you are able to take the higher of one of these two figures, being the same month's earnings from the previous year or an average monthly earnings for the previous tax year as well. Alternatively, if they have been employed for less than 12 months, you can use an average earnings since they started. So I think that's fairly easy to apply, I would hope. But again, if you need any assistance, let us know. Now, we know that the portal became live on the 20th of April. We've seen lots of people able to put in their claims, and I've heard anecdotally that the portal has not crashed. It's been accessible, and obviously people are hoping to receive their payments very soon. And they have said that potentially you would receive your payments within 6 working days. And you are, of course, to keep your records for 5 years, which will allow HMRC, of course, to audit your claims and the information you have. In terms of what I would recommend that you keep, it would of course be documentation, including obviously how you selected those workers in case they come back with a complaint, and also of course their written and signed consent, whether that's electronic or otherwise, of course, if they're from home. So even if they email in to say yes I agree, or they sign it digitally and send it in again, those are the types of things that you should be keeping. I also included in here, just briefly, obviously a list of the things that you will need to get ready when you are accessing the government portal in order to make your claims. So if you have any questions, don't by all means get in touch. My contact details are at the start and at the end of this session. My name is Paula Squire. Alternatively, do get in touch with one of our local employment solicitors or your usual contact. Now, what I have done is I pulled together a list of questions that we were asked on our past 2 webinars in order to give you a bit of a flavour of the types of questions we're being asked, and hopefully to pick up any questions that you may have as well. So what I'll do is very briefly run through those questions that we have been asked. So the first question was in respect of a director, and can a director be furloughed? If a director is also employed, so they need to be on PAYE, then yes, they are able to be furloughed. However, dividends are not able to be reclaimed through the HMRC scheme. A follow-up question to that is whether or not the director can carry out any work whilst on furlough. My answer to that is that they are able to carry out very limited duties in respect of their statutory minimum duties, but nothing more. So they wouldn't be able to go on and generate business or carry on marketing, etc. for their business. It would very much be very, very limited amounts under the Companies Act. The next question, do I have to top up the 20%? I think, as I've noted, no, you do not. However, all of this goes with what you are encouraging your employee to accept and what they do indeed agree to accept. The next question, what do I do if an employee refuses to go on furlough? My answer to that is that most employees haven't refused. I think a lot of it depends upon feeling involved in your thoughts around why you're making this decision to put someone on furlough, to really explain what it means, to explain what it means for the business, to explain what may happen next. So again, I think trying to go through those initial steps of agreement, and then I think if that doesn't work, then I would also go back to the contract and what else can you do in respect of dealing with these issues. Are you able to lay somebody off? Are you able to put them on short-term working, depending on the terms of your contract? Next question, can I withdraw a job offer which I have made? Very much, I think my answer to that depends upon how far along in the job offer you've gotten. Or have you sent out an offer letter? Have you sent out a contract? Has it been signed? Because very much normally, if you've gone very far down that road, then in which case the potential remit for you and potential liability will be the notice period that you may have had to give. So I think very much it depends upon your documentation and quite the level of acceptance you've gotten to, and obviously the reliance upon that. Better obviously to deal with that very, very quickly to allow the employee to perhaps go back to their previous employer or try to rescind their resignation if they're able. But do let us know if you'd like us to look over that contractual documentation. Another question here, do I have to wait to use the furlough scheme, or can I move through redundancies now? Very much the choice is yours. So if you are in a position where you do need to get on with the redundancies, then it should be something that you are able to do. You don't have to use the scheme, but again, you may want to consider using the scheme, for example, for notice periods, if applicable. Another question I've had is whether or not you can use the furlough scheme for maternity leave. There are some maternity payments you are able to reclaim as furloughed. So again, let us know if you have any more questions on that. But potentially the furlough scheme shouldn't really impact upon your employees if they're still off on maternity leave, reclaiming their statutory minimum entitlement stop. Should you require any further help in relation to layoffs, short-term working, reducing hours of pay arrangements, or redundancy and restructuring, please don't hesitate to let myself or one of the other employment and HR team solicitors know. Thank you so much for listening, and stay safe and stay well.